I believe that at least some of us has already, have a certain understanding and some kind of picture of what is actually the discussion is all about. So now I open the floor for any question to be asked. Can I see raise of hand? How many questions? How many of you intend to ask question? 1, 2, 3. 1, 2, 3, 4, 5, 6. Okay, I'll just stop it. Okay, proceed to the mic, please. There's a mic there. Sorry, before that I need to remind you that this is not an Islamic forum, Islamic discussion. This is an academic forum discussing legal and civil issue. I believe that every one of us know about this, right? Okay, please.
Thank you. I remain my humble self. Abdulkadir, Olaji Abdulkadir. That's my name. Regarding the issue, please, I want to comment on the issue whether a state can interfere in personal matters, in private matters. In human rights discourse, human rights is classified into two categories. We have what we call positive rights and the negative rights. The positive rights or the negative rights, those are the rights upon which the state cannot interfere. That is the private individual's right, otherwise called individual's right. A good example is the right to life, so to say. Then in positive rights, those are the rights that require state interference. But in the true sense, and in the actual sense, whether a right is positive or is negative, it requires a minimum degree of state interference. When you say you have the right to life, the state cannot protect that right to life without putting in place certain mechanisms. For example, police. If you say you have the right to life, then you must not terminate other people's right for you to protect your own right to life. So where I'm going, my own point is, a state has the right at any point, or the power at any point in time, to interfere and regulate private affairs, be it positive rights or negative rights. That is my first point of view. And with that in mind, I maintain that the state has the right to interfere in private affairs, to regulate the activities within its jurisdiction. Then secondly, in human rights discourse as well, we are looking at human rights from only one perspective. In human rights discourse, there are two major schools of thought. We have the universalist school and the cultural relativist school. I belong to the school of cultural relativists. The cultural relativist school believe that when you talk of human rights is not what is contained in international documents. It's not what you see in the Universal Declaration of Human Rights or the African Charter on Human and People's Rights. But human rights is determined or based also on the local cultural tradition of the people. And when we say culture here, I want to include, we say Islam, also, quote and unquote, because Islam has its own culture. So when we not determine what is right, or what is a crime, or what is right or wrong, then you must bear in mind the structure upon which a society is built. And that is where my question lies. What is the structure upon which Malaysia is built? For what will determine whether homosexuality is right or whether homosexuality is wrong? I believe that's the question for everybody to answer. Then the next one I want to make reference to is the issue of civilization. We tend to misconceive civilization with technological advancement. Civilization is different from technological advancement. Every society is civilized based on its own cultural values. The mere fact that a particular act has been allowed in UK or in US does not mean it should be permitted in Malaysia. Does not mean it should be permitted in my country, Nigeria. It all depends upon which structure the society is built. So thank you.
Before any one of you asks the question, perhaps you can specify the panelists that you address the issue, the question, which panelists you're actually addressing the question, and where you're coming from, and what is your name. next question.
Assalamualaikum warahmatullahi. My name is Muhammad Husni bin Muhammad Amin from Himpunan Keilmuan Muslim Hakim. I have two questions addressed to Dr. Farouk and Mr. Lim Chi Wee. Firstly, I would like to go with Dr. Farouk. You mentioned things about freedom, the freedom of choice. But I'm sorry, Mr. Farid, I have to go on the Islamic because he mentioned some names here which pertains to our religion. So he speaks about the importance of having this freedom of choice. He speaks about Adam and Eve. But then again, he says something about article or case 77. I don't know which code is it, but it sounds like that. I'm no lawyer, but he said that it's an archaic law. Now, isn't the story of Adam and Eve also archaic? Because it's in the past. And also, when you get to the mention of Surah Al-A'raf, and then suddenly he says that, no, let's not go into tafsir, because that particular verse speaks about the excesses of Prophet Lot's people, the people of Sodom. And then he talks about, when he talks about that, I'm asking, then why bring the verse in the first place? It appears that he's cherry picking. Pick this verse, but not this verse. Now, does the verse come into mind? Ya ayyuhalladhina amanu udkhulu fi silmi kafa mean anything to him? Now, to Mr. Lim Chi Wee, before I go into that, he says about the case whether we should repeal the code because it prosecutes political opponents. Now, if that's the basis for repealing that law, let's just repeal every other law that prosecutes politicians. Let's repeal SPRM. Let's repeal every other law that prosecutes politicians. Hell, we can just repeal every other law that prosecutes other people. And let's just live in anarchy. How you say that? And then to Mr. Lim Chi Wee, he mentions that lying is simple, but it's not a crime. But what about lying to a policeman, making false reports, or swindling other people's money? Aren't this built on lying? And he goes on talking about how other countries not prosecuting people based on homosexual behavior. You want us to decide for ourselves, but you start quoting examples from other countries. Where are you leading us to? Those are my questions. Thank you.
Okay, thank you. First of all, when I quoted Adam and Eve, because I wanted to give an example about human conscience, right? But I'm not going to dwell into the issues of what had happened in the Quran and so on and so forth. The idea is just to reiterate the point about we having our own conscience and we determine for ourselves to do right or to do wrong, and we have the right to repent when we do wrong. That is the most important thing. And that is what has to be understood. And if you want to talk about Prophet Lut, this and that, then call Ustaz Azhar Idros here and listen to him. You know, don't listen to us. Right? And with regard that, because I mentioned that it has to be repealed, because 377 is being used as a political persecution, and he was trying to be clever and saying that what will repeal all other laws? Surely it doesn't make sense, isn't it? Because 377 means that why was Anwar Ibrahim being persecuted under 377, saying that under 377B, which is consensual sex, when Saiful Bukhari said that it was non-consensual, that he was being forced. And he made an oath at this Wilayah mosque and saying that it was non-consensual. Why did the AG chamber formulate the accusation, the prosecution against Anwar to be consensual? So that shows that it can be used as a political instrument to persecute your political opponent. Doesn't that make sense to you? I mean, are you too clever to understand that, or too, I don't know. So it's so simple, right? The point is that the AG chamber is trying to what we call a perversion of justice. Is that in that case they're trying to do, because I was involved in this case from the beginning, and I knew that from the medical examination there was no evidence of injury. When there is no evidence of injury, it couldn't be non-consensual. It must be consensual. So to make it believable, how do you make it believable? Is to just frame it as consensual. It's as simple as that. You know, rather than trying to frame it according to what has been the complainant accused that it was non-consensual, and it's going to be very difficult for them to prove that it's non-consensual because there's no evidence of sexual penetration. So it was framed as consensual, and that's perversion of justice, and that's why this 377 has to be repealed. It's as simple as that.
I'm sorry if I'm a poor speaker and I didn't make myself clearer earlier. 377 covers the following sexual conduct. Okay? As Dr. Farouk said earlier, it does not distinguish between homosexual and heterosexual. So bear this in mind. So let's go to specifics. Because to answer your question, you're wondering why I say it's arcade. A woman giving a man a blowjob is an offense under 377. Okay? Again, I'm not asking you all to raise your hands. As adults, ask yourself this: have you ever either given or benefited from such a sexual conduct? If not, when you get married or you meet a boyfriend or a girlfriend, it may happen. So ask yourself, do we still want this in our statute books? When I would think that a number of adults, consenting adults, engage in this behavior. So why is it still in our statute books? Of course, some of you may say, aha, answer very simple. Don't repeal it, amend it, and apply only to same-sex. Yes, that may be an answer to address some of the concerns in this room. If you say you should exclude heterosexual, but then you're still left with the constitutional issues of equality and non-discrimination. All right, how do we deal with that? Okay, I'm going to give you the answer. Those of you who study law, you think about it for yourselves. And as to you quoting me to have said, abolish it because it is subject to abuse. No, I didn't say that. I said abolish it because it is archaic. And there have been any number of countries whose names I've listed there, which are still thriving civilizations, have not descended into Sodom and Gomorrah, which are still around, which have done away with it. All right? So that's where we're at. And then can I just elaborate a bit on what Dr. Farouk said? Dr. Farouk, sorry. Maybe soon come. Just like you, so. Okay, so, Anwar Ibrahim, I found it really ironic that the complainant and his father projected an image that they are victims, when, as Dr. Farouk said, the charge is consensual. So how can they be victims? You see? So that's why Dr. Farouk was said what he said in such passionate terms, because it defies logic. You consented, assuming the activity or the sexual conduct happened. You consented to it. How can you be a victim? So that's why the bar said what he said. You know, the AG shouldn't appeal. And I said that who is Saiful and his father to say AG should, and that they are victims? You know? So, okay, I hope you understood that.
I want to respond a bit to both speakers. It's regarding crime. Let's say we do admit, let's say, those who are married, or are not married but you have boyfriend, as we said. But you do those kind of prohibited or criminalized actions in your personal, private room. It's not on the beach, it's not on the road. No one see, no one complain. It doesn't matter, because crime depends on the actor's risk. And if it's exposed, it affects the public, there will be prosecution. If it's done in your bedroom, no one see it, no one feel irritated about it, that will be fine. But if you want to prosecute, let's say somebody drinks liquor. Let's say that you go to selective prosecution. For instance, somebody arguing that is selective prosecution. But you go on the streets doing criminal acts, or commits a crime, but that being provided or criminalized in the law, then there can be prosecution. But I think we all lawyers understand that this prosecution will be probably 90% rule of sustaining or winning the case, and you prosecute the case. But I would say, jangan bakar kelambu kerana marahkan nyamuk. Jangan runtuhkan rumah pesaka jika kita boleh perbaiki. Because when we make something collapse, it's difficult to rebuild. Pepatah Melayu kata, jangan terengantuk, baru terngadah. This is something we have to think. It's not because of one case. I remember Lord Denning had once said, blasphemy law is obsolete. 2 years after his statement, there was a prosecution of blasphemy when there was a publication of The Love That Dares to Speak that described how Musa commits sodomy. So you have a lot of examples, other examples that have been mentioned by both speakers, to show that there's something to think before we do. And the thing that we do, it must be beyond what we expect the next day. It should be for future generations of what we want this nation to be. Wallahu a'lam.